Send this video to someone you know who needs a 3-minute comprehensive guide about evictions here in California. Evictions here in California are generally referred to as unlawful detainers. An unlawful detainer is a legal proceeding by which a landlord can evict a tenant who is no longer complying with the terms of a lease or who fails to vacate once the terms of the lease are over. Unlawful detainer or UD cases generally have 5 phases. The first phase is known as the notice requirement. Before commencing a UD, California law requires landlords to provide their tenants with a written notice. A 3-day notice to pay rent or quit is just like it sounds. They will be evicted after the 3-day notice if they don't pay their rent. A 3-day notice to cure or quit is similar, but it's for a violation of the lease that is not payment of rent, and the tenant has 3 days to cure or vacate the premises. 30-day or 60-day notices are given when a tenancy is for month to month. Landlords have to give 30-day notices if the tenants have lived for less than a year on the property, and a 60-day notice if they've lived longer than a year on the property. A 90-day notice is also for special Section 8 evictions and other types of properties that are being taken off the market in certain circumstances. Landlords must properly serve the notice, either by personal delivery, substitute service, or posting and mailing, in compliance with California law. If the tenant does not comply with the notice, the next phase is filing and serving. The landlord can file the complaint in the local superior court, and they have to hire a process server to effect service of process. The next phase is tenant's response and discovery. A tenant can contest the eviction by filing an answer, challenge the legal sufficiency of the complaint by filing a demurrer, or challenge the service of process by filing a motion to quash service. Both landlords and tenants can engage in discovery at this point, demanding relevant documents from the other side. Tenants typically only have 5 days to respond to a UD complaint. The next phase is trial, which is generally scheduled within 20 days after a response. When the landlord wins, a judgment for possession is handed down. The last phase is eviction, or writ of execution. If a landlord has a judgment in their favor, they can go and seek a writ of execution. Also known as a writ of possession, this is delivered to the sheriff's office. The tenant will receive a 5-day notice that the sheriff is going to forcibly remove them from the property. And if the tenant doesn't vacate in time, the sheriff will forcibly remove the tenant and their belongings.